Buenos días, bienvenidos, damas y caballeros. Good morning, everyone. Dear panelists and audience, welcome to the World Law Congress, to the first panel round. And we will start this morning, in my biased opinion, with the most important panel, namely law, climate change, and nature. My name is Kari Kuusiniemi. I'm the president of the Supreme Administrative Court of Finland and also member of the Board of Trustees of the World Law Foundation. And before starting my career in the judiciary, I served as a professor of environmental law. I feel very honored to chair this panel, but I do have one concern, besides the fact that we don't have the pre-recorded presentation by Chief Justice Antonio Benjamin, but we also have 8 knowledgeable speakers, and we have a tight schedule, about 80 minutes in total. So I strongly urge us all to keep up with the timetable. This panel has been planned together with my dear colleagues and friends, Antonio Benjamin and Luc Lavrysen, who is here sitting beside me. Luc is the president of the Constitutional Court of Belgium, and these two are the most prominent figures in international environmental law. It's a privilege to cooperate with these prominent figures. We decided to focus this panel on 2 subjects, namely climate change and nature, but from the perspective of law. Not only judges, but also lawyers, academics, and other persons who are interested in and involved in legal regulations affecting climate and nature. Obviously, today, there's no need for wide introductory remarks concerning the effects and relevance of tackling climate change and biodiversity loss. At present, climate change is showcasted in extreme weather conditions, and we are undeniably on the path towards exceeding the maximum target of 1.5 degrees warming. Nor is it necessary to remind that we are facing the 6th extinction wave, and the loss of biodiversity, especially in the tropical rainforests, is a crucial issue also with regard to climate change. These are fatal threats for the humankind, especially the future generations. And still, there is denialism and lack of political will, or at least courage, all over the world. And the rules-based system of international law seems to be at the edge of collapse. But despite these pessimistic words, I sincerely hope that the forthcoming presentations and discussions bring us some hope concerning the role of law and courts in saving the planet. How can we highlight the role of courts, judges, and more generally law in tackling these most critical challenges to our destiny, our common future, as was phrased in the Brundtland Commission report almost 40 years ago? In my opinion, it's not very helpful to concentrate on mourning the present situation. I feel it more productive to ponder what we can do to make things develop into more positive direction. So I'm really looking forward to hearing insights from our panelists. Thank you for being with us here today, and especially concentrating on what can be expected from legal instruments and courts of law in the complex playing field of multinational agreements, regional, such as EU, and national politics? What is the role of strategic litigation in court cases where governments are alleged not to do their share? Globally, we have hundreds or even thousands of examples of climate and nature protection cases where, for instance, nature as such, Pachamama, or its parts, such as rivers, have been afforded standing in courts. But sometimes it's questionable whether there are effective remedies in place, for instance, environmental NGOs. We have climate cases in European courts, for example, the European Court of Human Rights, the so-called Klimaseniorinens case. In many constitutional courts, just like the Neubauer case concerning climate law in German Federal Constitutional Court, and in many Supreme or Supreme Administrative Courts, for instance, the paradigm case of Urgenda from the Dutch Supreme Court, and a very fresh case from the Supreme Court of Canada, which was originated by youngsters. But I would like to mention some judgments of my own court, the Finnish Supreme Administrative Court, concerning climate appeals, where against the normal principles of our national administrative procedure, we had a very extensive interpretation, and we examined the appeals by certain NGOs, and our decision was largely based to the argumentation on the Klimaseniorinens case in the European Court of Human Rights. But there would be an endless list of examples. The basic ethos of the organizing society of this prestigious event, the World Jurist Association, is based on the rule of law. The motto is to strive towards a world governed by law, not by force. However, regrettably, we are gliding farther away from this ideal. The rule of law index is backsliding globally. Polarization and populism ruin the trust in the institutions that keep the societies on track. Concentrating on the rule of law, it's intriguing to grasp the courts and judges' role if the government is not safeguarding human rights and fundamental rights of present and future generations. As a point of departure, tripartition of state powers shall sure be acknowledged. The courts are not there to make political decisions. This is the prerogative of democratically elected organs. But if these do not take care of their obligations according to international agreements and national constitution and acts of parliament, then the courts shall rectify the neglected measures, not choosing goals, not defining measures, but drawing the frames of legality. And so, now we are ready to start our journey. It was intended that we start with 2 presentations concentrating on nature issues and then continue with presentations on climate change. But we were supposed to have the pre-recorded presentation by Chief Justice Antonio Herman Benjamin from Brazil, but for technical reasons, it seems so that we have to make this seminar without Antonio's very insightful presentation. I have listened to it, and I can assure you it was a very nice presentation, but you just have to believe in me, but we're not able to reproduce it at the moment. Or Pablo, you haven't got any reply from Antonio, because Antonio Benjamin, who is a very busy court president, is... Okay. He's namely in a conference in Morocco, Rabat, at the moment, and that's why he couldn't be present here. But nevertheless, we have to move forward, and the second speaker about the nature issue here is to my right, President Lavrysen. As mentioned, he was in the group planning for this panel, and in some earlier programs he also appears as a co-chair, but then we needed one excellent speaker for nature issue, and that's why I stayed as the only chair, and Luc was kind enough to take care of the presentation. And as mentioned, besides being the president of the Belgian Constitutional Court, the Flemish section, he has been justice at the court since 2001, and he was also a part-time professor of environmental law in Ghent University, now Professor Emeritus. He's also president of the European Union Forum of Judges for the Environment and the current chair of the Task Force on Access to Justice of the UNECE Aarhus Convention. So, Luc, please, the floor is yours.
So, thank you very much, Kari, for this introduction. So, I will speak about nature protection and restoration. And according to the Global Assessment Report on Biodiversity and Ecosystem Services of 2019 of the Intergovernmental Platform on Biodiversity and Ecosystems, that's an independent intergovernmental body which was established in 2012 and has now nearly 150 member states, biodiversity is under threat worldwide. And the assessment contains the following key messages. Nature's dangerous decline is unprecedented. Species extinction rates is accelerating. Current global responses are insufficient. Transformative changes are needed to restore and protect nature, and opposition from vested interests can be overcome for the public good. So on the global scale, the main legal instrument to halt this negative trend is the Framework Convention on Biological Diversity, which was signed in Rio de Janeiro in 1992. And that convention entered into force in December 1993. It has now 196 parties, so that's nearly the whole world community, including the European Union as a supranational organization, but with two notable exceptions, the United States and the Holy See. It has three main objectives: the conservation of biological diversity, the sustainable use of components of biological diversity, and the fair and equitable sharing of the benefits arising of the utilization of genetic resources. So this framework convention has been complemented with the Cartagena Protocol on biosafety and the Nagoya Protocol on access to genetic resources and the fair and equitable sharing of benefits arising from their utilization. 20 biodiversity targets were set by the COP10, the Conference of the Parties number 10 of the Convention of Biodiversity in 2011, to offer a framework in which the world and individual countries can address the growing rates of biodiversity loss, the so-called Aichi biodiversity targets that should have been met in 2015 or 2020, respectively. Aichi target number 15, for example, aimed to enhance the resilience of ecosystems through the restoration of 15% of degraded land by 2020. But the world community did not deliver as promised. According to the UN Global Biodiversity Outlook report number 5, only 6 of the 20 targets, including the land and ocean conservation target, were deemed in 2020 to be partially achieved, while 10% of the targets saw no significant progress. Progress towards the target of restoring 15% of degraded ecosystems by 2020 was limited. Meanwhile, these targets have been replaced by the Kunming-Montreal Global Biodiversity Framework that sets 23 action-oriented global targets for urgent actions over the decade to 2030. The actions set out in each target need to be initiated immediately and completed by 2030. Together, the results will enable achievements towards the outcome-oriented goals for 2050. It includes the restoration of 30% of all degraded ecosystems and the conservation of 30% of land, waters, and seas. And it is within this global framework that the European Union has taken legislative action in addition to the two main legal instruments to protect biodiversity within the European Union, so-called birds and habitats directives. Both directives are of utmost importance for nature conservation in the European Union. And a key element is the so-called Natura 2000 as a very large network of protected areas. European and national judges have played a very important role in enforcing those directives by interpreting them in a broad and result-based way. The Court of Justice of the European Union delivered more than 100 judgments on the interpretation and the implementation of the Birds Directive, of which a quarter by way of so-called preliminary rulings on requests of national judges dealing with nature protection cases. And the court delivered 88 judgments on the Habitats Directive, of which nearly half by way of such preliminary rulings. Although of very great importance, those directives have not been able to stop the decline of biodiversity in the European Union. Despite some progress, most protected habitats and species have either poor or bad conservation status, according to the European Environment Agency. Destruction of habitats, overexploitation of resources, pollution, climate change, the introduction of invasive species, urban sprawl, and landscape fragmentations are only some of the reasons behind this decline, which affects terrestrial and aquatic species, their habitats, and ecosystem services. Following the European Union Biodiversity Strategy for 2030, the European Union legislation has been complemented last year with the European Union Nature Restoration Law, or more precisely, Regulation 2024/1991 of June 2024 on nature restoration. The regulation aims to restore ecosystems, habitats and species across the European Union land and sea areas in order to enable the long-term and sustained recovery of biodiverse and resilient nature, and to contribute to achieving also the European Union's climate mitigation and climate adaptation objectives and international commitments. The regulation combines an overarching restoration objective for the long-term recovery of nature in European Union's land and sea areas with binding restoration targets for specific habitats and species. And these measures should cover at least 20% of the European Union's land and sea areas by 2030, and ultimately all ecosystems in need of restorations by 2050. And the regulation contains very specific targets based on existing legislation for wetlands, forests, grasslands, rivers and lakes, heath and scrub, rocky habitats and dunes, in view of improving and re-establishing biodiverse habitats on a large scale, and bridging back species populations by improving and enlarging their habitats. Furthermore, it provides targets concerning pollinating insects, forest, urban, agriculture, and marine ecosystems and river connectivity. The 27 European Union countries are expected to submit national restoration plans to the European Commission with the 2 years of the regulation coming into force, so by mid-2026, showing how they will deliver on those targets. They will also be required to monitor and report on their progress. The European Environmental Agency will draw up regular technical reports on progress, and the European Commission, in turn, will report to the European Parliament and to the Council on the implementation of the Nature Restoration Regulation. The judiciary, both at European Union and national level, is, as I already mentioned, playing an important role in upholding biodiversity law. It has to be seen what will be its role by upholding this new nature restoration law. It might go from issuing suspension orders of activities, breaching the applicable biodiversity legislation, for instance, through fast-track procedures when available, to ordering compensation for the damage already done to be paid to nature restoration funds. At the European Union Forum of Judges for the Environment, we have started exploring this topic. First, through the launch of what we call the BioVal tool, that provides courts and legal professionals a tool to calculate compensation for the damage caused to nature, and has been successfully used already in some cases in Belgium, for example, with the financial compensation to be paid to a public nature restoration fund. Then also through the work and exchanges that will take place at our next annual conference of the Forum in October 2025 in Copenhagen. It's also the conference where I hope that the presidency will go that side to Kari Kuusiniemi as our new president, and the conference will focus also on the topic of nature protection and restoration, with presentations by international and European institutions, as well as national judges from Europe, and a general report of all national inputs. So this in a nutshell, what I had to say about nature protection and restoration, and thank you for your attention.
Thank you, Luc. It was a very versatile and overarching survey on the international basics of protection of biodiversity and nature protection, and also with regard to restoration. So this is a very good basis for the nature protection basis of this panel. But I think that we will save our eventual questions and comments for the end of the panel, because I would predict that we would have a little bit limited time at our disposal. But thank you so much, Luc. And I will then pass the floor to the next speaker, the first speaker in the climate change part of the panel, which will be started by Milagros de Camps, Chief Sustainability Officer at InterEnergy Group. She holds not only a law degree, but also master's degrees in international business law and environmental management, with a specialization in energy and climate change policy. With over 20 years of experience, believe or not, she has originated and executed climate change mitigation and adaptation projects in more than 15 developing countries. She has led research on energy transition and climate change policies, and held key roles in important institutions and companies with a high impact in the climate field, such as chairing the Green Climate Fund and serving as a climate policy and finance specialist at the Global Green Growth Institute. She also served as Vice Minister of Environment and Natural Resources in the Dominican Republic. And now she will speak about climate change legislation and how to bridge regulation and implementation for a nature-positive future. Please, the floor is yours.
Thank you very much. First of all, I want to give you all a very warm welcome to my country. It is a pleasure to have you all here, and particularly discussing important topics such as climate change and nature positive, in a nature-positive world. I usually start interventions providing a context of what climate change means, not only in global terms, but also in regional and national terms. Today, because being mindful of time, I'm gonna, from 10,000 feet, give a brief overview. We know that climate change is the biggest issue that we face as humanity. There is consensus between specialists and between scientists and between nations of the cause of climate change and what we need to do it. There has been different international legal agreements that address the issue of climate change, and as we move forward, we see as well that other international treaties are also finding some type of coherence and complementarity, leading towards a connection of causality between climate change and biodiversity laws or pollution and other things. So today I'm going to speak both from a regional and a cross-sectoral perspective, but briefly, and just to also contribute to the context and put it in place in Latin America, which is the region where I've worked most of my life. So as we know, Latin America is not a major emitter of global greenhouse gas emissions. It only represents about 8.3% of global greenhouse gases, and in particular case of the Dominican Republic, only 0.08%. So it's a marginal amount of greenhouse gases when you put it in global terms. However, we're one of the most affected regions and one of the most affected countries because of our condition of being a small island developing state. We have also additional vulnerabilities to sea level rise, Category 5 storms, deadly urban floods, and prolonged droughts, which are affecting our economy, but also food insecurity and not distant threats because they're part of our present. And this vulnerability demands legal frameworks that are ambitious, as ambitious as the challenges that we face. And across the region, we are seeing progress. However, Globally, we're seeing progress. However, across the region, we only see that 8 countries in Latin America and the Caribbean have adopted national frameworks. And few countries have passed comprehensive climate framework laws that incorporate key dimensions like climate justice or migration, which is also a big issue. And as of 2021, more than 22 million people were displaced globally due to climate-related disasters in Central America, particularly in the dry corridor, which is home to 11 million people who live under constant threat from the drought and other disasters. So today, and currently from the private sector, I see how the absence of legal certainty and legal clarity can deter investments in clean energy and nature-based solutions. But also because companies want to comply and they need harmonized ESG standards, they need disclosure requirements, they need carbon market rules that are predictable and fair, and law must not only regulate behavior, but it should create the conditions for innovation, investment, and trust. And how do we translate in legal and judicial terms the complexities of a multidimensional phenomenon such as climate change, which is challenging in all aspects of civilization, because it affects the socio-political structure, the survival of the identity and livelihoods of communities and their cultures, and the future of human life on the planet. And a significant number of countries either acknowledge that there's a scientific consensus on the causes and impacts of climate change, or rely on IPCC reports as the authoritative science. And this is not an easy task, because if you've ever participated in climate negotiations or any type of international negotiations, it's not easy to find consensus between 196 countries. So IPCC findings characterize the Caribbean as most vulnerable to sea level rise and other climate change impacts, and between 8.7% and 50% of the Caribbean islands could become entirely submerged under a conservative projection scenario. The UNFCCC, which is the United Nations Conventions on Climate Change, Framework Convention on Climate Change, sets the main standard for what is international law in regards to climate change. And the objective of this convention is to stabilize greenhouse gas emissions concentrations so it does not interfere with human systems. And the primary focus of the states have been identified without prejudice to other relevant primary obligations arising from specialized areas of international law. The state's specific international mitigation obligations are complemented by important general principles of law and customary obligations, including inter alia, states' customary international obligations not to cause transboundary harm, and the fundamental right of every state to survival, as well as relevant primary obligations under international human rights law to promote, respect, and preserve people's right to self-determination and their right to develop, as the effective exercise of these two rights is being hindered by the deleterious impacts of climate change. And through their composite and continuous acts, as well as through their omissions, like failure to adopt the necessary legislations and administrative measures, states have breached and continue to breach primary obligations that have been identified in the UNFCCC convention and other conventions. We also acknowledge that the relevant applicable law is not confined only to international law or environmental international law. It should also identify states' obligation with respect to climate change in other specialized areas, including international law of the sea, international human rights law, and principles enshrined in the UN Charter, such as the obligation to respect the state's territorial integrity and to several general principles of law and customary international obligations, including the duty of due diligence, of principle of common but differentiated responsibilities and respective capabilities, the principle of intergenerational justice, and the duty to cooperate, and the customary obligation not to cause transboundary harm, like I've mentioned before. So basically, we have a legal framework that provides us, like I mentioned before, the framework, but we've had states we've tasked states to come up with their national laws to make this actionable, to make this executable in each of their countries, but we have not seen so many countries that have come up to the mission. We need strong national governance because it is essential to address worrying shortfalls in the ambition, in the implementation and the credibility of national commitments to reaching net zero emissions that continue to be indicated by multiple scientific reports. We also must follow the country's political promise of a net zero target. We need to make countries accountable. We need to make private sector accountable, and we need a significant task of making this pledge a reality, which requires a whole body of supportive governance infrastructure. And there are drivers that move governments towards making these promises and these commitments and integrating and implementing them. We have international peer pressure and leadership, we have supranational legal requirements, historical context, political culture, economic opportunities and access to finance, and domestic social pressure and just transition, as well as political party competition, climate vulnerability, and science and knowledge. We've identified those as the key drivers. However, to assist countries in developing robust governance frameworks and to provide internationally comparable data, I particularly worked in an assessment of the different legal frameworks, national legal frameworks available, but I have particularly highlighted the work of 9 climate governance functions from 26 laws from around the world. And the analysis showed to date that the main focus has been on strategy setting and narrative and long-term objectives in the national legislations. But there is less emphasis in the laws on establishing mechanisms to generate independent knowledge, coordinating arrangements, and on mainstreaming across different sectors like energy sector, agriculture, and other sectors that have a big impact on climate change. And although net zero laws are making strong linkages to most of the 9 core climate governance functions, countries are facing implementation challenges in similar areas and face practical difficulties in aligning policies with long-term objectives and overcoming implementation hurdles. I originally proposed a taxonomy identifying and comparing existing legal mechanisms to reach net zero across the jurisdictions, and identifying and analyzing different legislative and regulatory mechanisms that incorporate net zero mandates, but also arising from different legislation in other countries. And we've identified the key elements that national laws should have to effectively address and bridge from ambition to action. So first, setting a priority. In the case of the Dominican Republic, our priority is adaptation because we're highly vulnerable. That doesn't mean we're not doing mitigation work, but adaptation is a priority. Our mitigation goal is just transition and carbon neutrality by 2050. But we've also identified that there's a need for institutionalizing climate change. We need clear governance structures. We need a governance body that is identified, and we need to address also on a multidimensional level responsibilities to other sectors. We need different specific sector responsibilities. We need instruments of application of climate change and the incorporation of climate change and mainstreaming of climate change in other policies, and also financing instruments and different systems of information. Closing now, we have, as climate change impacts intensify, our legal system must also evolve to protect the most vulnerable, and this includes reorganizing the rights of nature, recognizing the rights of nature, supporting climate migrants, and expanding access to justice. And judges and nations must be empowered with climate science, and regulators must have tools to enforce compliance. But also citizens must be equipped with the legal means to defend their rights. And with this, I close. Thank you.
Thank you so much. I think your presentation linked very well to President Lavrysen's nice intervention, and you touched very well upon different levels of measures tackling climate change and also its kind of repercussions to the protection of biodiversity. I picked up especially what you were talking about, the role of private enterprises in combating climate change, and I think that's also a kind of hope, sign of hope in the world where governments may be not willing to reach the net zero targets. Thank you so much. And now, as we started our journey in this panel from Belgium, and then we came back to the beautiful Dominican Republic, And now we will move again rather far away to China. We have here the honor to hear the presentation of Mr. Yinqiang. He is the president of the High People's Court of Fujian province and also a justice of China, Supreme People's Court system maybe. And he will tell us about the ideas of the role of environmental justice to safeguard the ecological civilization development. And he will speak in Chinese, but luckily we do have a very capable interpreter here among us. Please, President Jin, the floor is yours.
Thank you.
Excuse me, the microphone for the...
Thank you. 各位来宾、女士们、先生们、朋友们，
Distinguished guests, ladies and gentlemen, friends.
大家好。首先，对本届世界法律大会在圣多明各成功召开表示热烈祝贺。
Good morning. First of all, I would like to extend my warm congratulations on the successful convening of the World Law Congress in Santo Domingo.
我是中华人民共和国福建省高级人民法院院长、2级大法官金银强，很高兴参加本次会议，并同大家分享中国推进环境资源司法工作的一些情况。中国法院深入贯彻习近平生态文明思想和习近平法治思想，牢固树立和践行“绿水青山就是金山银山”的理念，全面加强环境资源审判工作，主要做了以下几个方面的工作。
I am Yinqiang, President and Justice of the High People's Court of Fujian Province of the People's Republic of China. It is my great pleasure to attend this Congress and share China's perspectives in promoting judicial work in the field of environment. Chinese courts are committed to thoroughly carrying out Xi Jinping thought on ecological civilization and the rule of law, firmly upholding and practicing the concept that lucid water and lush mountains are invaluable assets, and strengthening all-round adjudication on environment and resources. To this end, our efforts have focused on the following aspects.
一是不断完善环境资源法律适用规则体系。 环境资源案件所涉及法律关系往往较为复杂，案件审理适用的程序规则、裁判机制均有专业性、特殊性。近年来，中国法院深入总结司法实践中的成熟经验，不断提供各类司法规则、法治产品，满足司法需求，完善制度供给，累计制定修订各类环境资源司法解释21件。 发布规范性司法文件22件，全面提升环境资源审判工作质量和水平，强化案例指引，发布环境资源指导性案例40件，专题典型案例45批447件。人民法院案例库收录环境资源审判参考案例350多件，指导各级法院准确适用法律，持续提升 全社会生态环境保护法治意识，促推规则构建，通过健全国际案例交换分享、法律适用交流机制，为构建全球环境治理规则体系贡献中国司法智慧。如在绿孔雀栖息地保护案中，中国法院突破有损害才有救济的传统理念，支持了保护预防性公益诉讼，将生态环境司法保护提升至事前， 具有重大示范价值。联合国环境规划署现已收录4批45件中国环境司法案例和8部环境司法报告。
First, we have been improving the system of rules for the application of environmental and resource-related laws. Environmental and resource-related cases usually involve complex legal relationships and necessitate specialized procedural rules and adjudicatory mechanisms applicable to the trials. In recent years, Chinese courts have thoroughly drawn on experiences from judicial practices and continuously provided various judicial rules and rule of law products to meet judicial demands. We have worked to improve institutional frameworks. China has formulated and revised a total of 21 judicial interpretations on environment and resources, issued 22 regulatory judicial documents, and comprehensively improved the quality and standard of environmental and resource-related adjudication. We have strengthened guiding role of typical cases. China has released 40 guiding cases for environmental adjudication and 447 typical cases on special topics. The database of the People's Courts has included more than 350 reference cases guiding courts at all levels in accurately applying the law and raising public awareness of the rule of law in environmental protection. We have been promoting the formulation of rules through advancing mechanisms for international case exchanges and legal application dialogues. China has contributed its own judicial wisdom to building a system of rules for global environmental governance. For example, in the case of green PFOS habitat protection, the Chinese court went beyond the traditional concept that relief can only be granted when damage has occurred, ruling in favor of the preventative public interest lawsuit. This shifted the ecological and environmental judicial protection to a preventative stage with significant demonstration value. The UNEP has now included 45 Chinese cases of environmental justice and 8 environmental judicial reports.
二是不断加强环境资源审判体制机制建设。中国法院持续推进环境资源审判专业化建设，为公正高效审理环境资源案件、促推生态环境保护治理提供有力支撑。完善专业化审判机制，环境资源案件涉及民事、刑事、行政3大诉讼。中国法院稳步推进3大审判职能统一归口，并实现审判理念、规则、程序的融合。中国已有1200余家法院实现环境资源专业化审判机制构建，有力促进了民事赔偿、刑事追诉、行政行为合法性审查科学衔接。如在三清山巨蟒峰损毁保护案中，中国法院发挥专业化审判机制作用，在依照刑事、民事诉讼程序分别审理的基础上，确保当事人承担刑事责任与民事责任的准确均衡，推进集中管辖，结合特定区域生态环境保护立法，以各类生态系统及生态功能区为单位，探索实行环境资源案件集中管辖，并在南京、昆明等地设立专门集中管辖的环境资源法庭8个，实现环境资源一体化保护，推进跨域协作，注重各地法院内部协同，因地制宜，加强跨区域环境资源司法协作。长江黄河流域、秦岭山脉、国家公园所在地相关法院分别签订司法协作协议，携手提升系统保护水平。
Second, we have been boosting the systematic and institutional construction for adjudication on the environment and resources. Chinese courts have continued to promote the specialized development of the environmental and resource-related adjudication to provide support for fair and efficient trials, as well as ecological and environmental protection and governance. We have been advancing the specialized adjudicatory mechanism. Environmental and resource-related cases involve 3 major categories of litigation, which are civil, criminal, and administrative. Chinese courts are steadily promoting centralized management of these 3 adjudicatory functions and integrating adjudicatory concepts, rules, and procedures. More than 1,200 Chinese courts have already built a specialized mechanism for adjudication on environment and resources, which has significantly facilitated the lawful connection of civil compensation, criminal prosecution, and review of the legality of administrative acts. For example, in the case of protecting against damage to the giant python peak of the Sanqingshan mountain, the Chinese court leveraged the role of the specialized adjudicatory mechanism to make sure the defendants assumed accurate and balanced criminal and civil liabilities based on separate trials according to the criminal and civil procedures. We have been promoting the centralized jurisdiction. In alignment with legislation on ecological and environmental protection in specific regions, we have explored centralized jurisdiction of environmental and resource-related cases based on various ecosystems and ecological functional zones. We have exclusively established 8 environmental and resource-related tribunals in places such as Nanjing and Kunming, with centralized jurisdiction to achieve integrated protection for the environment and resources. We have been promoting trans-regional collaboration. We have paid close attention to internal coordination between courts of various regions and strengthened trans-regional judicial collaboration in the fields of environment and resources based on local conditions. Courts located in the Yangtze River and Yellow River basins, the Qinling Mountains and national parks have respectively reached judicial cooperation agreements to jointly improve the level of systematic protection.
3是不断创新中国特色。3是不断创新中国特色环境资源裁判执行方式，构建多元化执行方式。中国法院不断丰富司法措施，责令环境侵权人严格履行修复义务。目前已在各类生态重点区域设立综合性生态环境司法保护基地1000余个，建立生态系统服务功能损失赔偿机制。中国法院和相关科研机构紧密结合，出台统一的森林生态系统服务功能损失价值量核算方法，完善专家辅助人制度，环境资源案件专业性强。中国法院创新性引入专家陪审员、生态技术调查人员等参与诉讼活动，提升案件审理专业化水平的同时，节约大量鉴定及修复费用。
Third, we have been innovating the method for enforcing environmental and resource-related rulings with Chinese characteristics. We have adopted diversified enforcement approaches. Chinese courts continue to enrich judicial measures and order environmental offenders to strictly fulfill their restoration obligations so as to promote the timely and effective restoration of the damaged ecology and environment. We have established a compensation mechanism for the loss of ecosystem service function. Through close cooperation with relevant scientific research institutions, Chinese courts have formulated a standardized method to calculate the value of losses in forest ecosystem service functions. We have been optimizing the expert assistance system. Given the strong professionalism of environmental and resource-related cases, Chinese courts innovatively engaged expert assessors and ecological technical investors in litigation activities.
中国式现代化是人与自然和谐共生的现代化。中国法院愿意将我们的做法与经验与世界各国同行分享，也期待世界法律界同仁们开展实践探索，共绘未来美好的法治蓝图。
Chinese modernization is the modernization of harmony between humanity and nature. Chinese courts will continue to learn and draw on other countries' advanced practices in judicial civilization. Meanwhile, we are also willing to share our practices and experiences with our counterparts all over the world. We look forward to work together with our colleagues from the legal profession around the world to strengthen discussions and exchanges and carry out practical experiences exploration in both environmental justice and other fields.
谢谢大家。
Thank you.
Thank you, President Jin. It was interesting to learn to know about the central concept of ecological civilization in the environmental law thinking in China, and also to learn about different procedures, civil, administrative, and criminal, and the impressive number of cases you do have. We only can wish you good luck in your very, very big challenges in developing the system. And now, our next speaker comes again from Europe, representing the future generations, which is good for the topic of the conference. Her name is Eva Zemani, and she is second judge in the legal service unit of the Albanian Supreme Court. And she graduated from the magistrate school in 2019 and was conferred the title judge then. And as said, now she's serving at the Supreme Court and in the administrative chamber. And she conducts legal analysis and research on issues related to access to justice in environmental matters. And now we will hear her insights concerning access to justice in environmental issues from the Albanian perspective. Please, Eva, the floor is yours.
Thank you very much. Honorable Chair, esteemed members of the panel, distinguished colleagues, and dear participants, Albania has made substantial progress in transposing European Union directives, including the Environmental Impact Assessment and Strategic Environmental Assessment directives. Albania is party to several key international environmental conventions, such as the Aarhus Convention, Istanbul Convention, Kyoto Protocol and Paris Agreement, Basel, Rotterdam, Stockholm Conventions, Ramsar Conventions on Wetland, the Bern, Barcelona, and Bonn Conventions. But although several international agreements have been ratified and certain domestic laws are in place, the environment itself has no voice. Therefore, justice must speak for it. Access to justice in environmental matters is not merely a legal issue, but is a human issue. It concerns clean air to breathe, safe water to drink, and the right to live in a healthy environment. Access to justice in environmental matters means that individuals, communities, and organizations have both the legal right and the practical ability to seek judicial and administrative remedies when environmental rights are infringed. The Supreme Court of the Republic of Albania plays a pivotal role promoting judicial review in such matters, and I would like to present key cases in which the Albanian courts have upheld access to justice for individuals and interested groups in environmental matters. And the first case, I've named it the Valbona Valley hydropower plants. In this case, the plaintiffs were a community of 27 residents from Margiga village in the northern Albania and the Land Association. The plaintiffs claimed that the construction and operation of the hydropower plants in the Valbona Valley area may seriously damage the environment of Valbona National Park. The plaintiffs also requested interim reliefs, specifically the suspension of the implementation of the concession contract until a final and binding court decision. While the lower administrative courts dismissed the request for interim measures, the Supreme Court of Albania upheld it, relying on a systematic interpretation of Article 9 of the Aarhus Convention, along with relevant provisions of Albanian administrative law. The Albanian Supreme Court affirmed that associations and interest groups have legal standing to initiate environmental litigations, providing they demonstrate a sufficient interest in the material at hand. The Albanian High Court emphasized that the damage caused by the continuation and implementation of the concession contract and related permits would be serious, irreversible, and immediate, as the project continuation could lead to further potential and harming the environment. The second case I would like to present is the case I've named the slaughterhouse in the forest case. This case refers an NGO along with residents impacted by a decision to allow a slaughterhouse to be built in a forest they had planted, challenging the decision in the court. The Administrative Court of Appeal had initially ruled that under the Albanian law, associations and interest groups can challenge the laws or acts that harm the public interest, but not individual administrative acts unless there is a direct harm to legitimate public interest, and individuals must demonstrate a direct connection to the contested act. The High Court of Albania suspended the development permit, drawing on the jurisprudence of the European Court of Justice, particularly the well-known Slovak Brown Bear case. In that decision, the Grand Chamber held that although Article 9 of the Aarhus Convention lacks direct effect on the EU law, its broad wording reflects a clear objective to ensure effective environmental protection. Accordingly, member states are required to interpret and apply their national procedural rules in a manner that does not make it particularly impossible to exercise rights derived from EU environmental law and guarantee individuals' access to court. And the last case I would like to present comes from the court of the first instance of Administrative Court of Tirana. Is the Vjosa River Hydropower Project. The Kalivac hydropower project on the Vjosa River, one of Europe's last wild rivers, faced great opposition from the Ministry of Environment, which issued a negative environmental statement due to the project's significant impacts on the biodiversity, water quality, and the ecosystem. Despite these concerns, the project developers challenged the ministry's decision by filing a lawsuit to annul the environmental assessment. Civil society organizations and 39 local residents intervened in the lawsuit, challenging the project's approval. In this case, the Administrative Court of First Instance of Tirana ruled in favor of the local residents, affirming the importance of public participation and environmental justice. This case became a landmark decision as it eventually led to the establishment of Vjosa National Park, the first wild river national park in Europe, securing so long-term protection for Vjosa River and its unique ecosystem. This project has also been strongly opposed by civil society organizations, national and international celebrities. In closing, I would like to emphasize that access to justice in environmental matters is not only a legal right, but is a fundamental instrument to protect the environment, upholding human rights and reinforcing democratic participation. While challenges persist, the evolving body of Albanian case law reflects a judiciary increasingly committed to environmental protection and public engagement. In closing, the path ahead is one of continued progress and collaboration. By strengthening Albanians' commitment to environmental justice, we are not only advancing legal framework, but we are also trying to secure a healthier and more sustainable future. Thank you very much for your attention.
Thank you, Eva, for your great and concise presentation. From the point of view of a judge, it was very joyful to hear about an analysis of 3 real court cases concerning access to justice, and I became impressed and convinced that Albania is on a very good path to her way to European Union and harmonize the legislation and law. Thank you so much. And then we come again back to the Americas. We have the next speaker, Pablo Lorenzetti, who is judge of the Civil, Commercial and Labor Court of Appeals in the city of Rafaela in Argentina. He's also professor and coordinator of the environmental law specialization program at University of Buenos Aires and specialist in some other units of universities. And Pablo will deliver his speech in his mother tongue, Spanish. Por favor.
Thank you very much, Chair. Good morning, everyone. As we only have 7 minutes to speak, I will speak in Spanish, which is my own language, to do it faster, and also because we are in Dominican Republic, where people speak Spanish too. So, las personas hispanohablantes pueden descansar un poco la oreja y sacarse el auricular. Teniendo en cuenta la heterogeneidad que hay de culturas jurídicas en este panel tan interesante y lo que escuché hasta recién, me parece que lo que yo puedo aportar son algunas ideas sobre cómo afrontamos los litigios vinculados al cambio climático y a los derechos de la naturaleza en el sur de nuestro continente. En esa idea hay muchísimos desafíos que los tribunales de nuestro continente han afrontado. Yo voy a seleccionar nada más que 3 porque tenemos muy poco tiempo. El primero de ellos es el conflicto que normalmente se genera entre el ejercicio de los derechos individuales por un lado y el ejercicio y la tutela de los derechos de incidencia colectiva por el otro. La persona más importante de la historia de nuestro país, Argentina, que es el Papa Francisco, a quien aprovechamos para homenajear aquí, ha dicho que los principales causantes de los daños ambientales somos los seres humanos. Ustedes pueden ver la encíclica Laudato Si, por ejemplo. Entonces, hay conflicto entre el ejercicio del derecho de propiedad, de la industria lícita, de la libertad de contratación, porque se contamina el ambiente y se incrementa el cambio climático. ¿Cómo solucionamos esto en nuestra parte del continente? Bueno, la Corte Interamericana de Derechos Humanos ha establecido criterios de prelación, o sea, la tutela del ambiente y los bienes comunes es un presupuesto o un prerequisito para el disfrute de los demás derechos fundamentales. Y también las constituciones de nuestra región tienen consagrado claramente el principio del desarrollo sostenible. Y en nuestro país tenemos una norma muy importante, que es el Código Civil y Comercial de la Nación, que cumple 10 años de vigencia este año. Aquí tenemos a uno de sus redactores, que establece criterios también de prelación y de armonización y de compatibilización entre derechos individuales y derechos de incidencia colectiva. Hemos trabajado estas ideas, el profesor Antonio Benjamín la ha trabajado también en Brasil, bajo la noción de la función ecológica o de la función socioambiental en el ejercicio de los derechos fundamentales. Esto quiere decir que es necesario internalizar los costos y pasivos ambientales en las actividades económicas. O sea, no solo sancionar a las empresas o a las economías para que no crezcan ni produzcan, sino que lo que en realidad se busca es desarrollar el crecimiento económico incorporando la variable ambiental a todos los procesos. Y cuando la tensión entre derechos fundamentales hace que los jueces y juezas debamos tomar, como decía Lavrysen, opciones trágicas, cuando no queda otra alternativa, hay un principio que se ha desarrollado muchísimo en nuestro continente, que es muy útil para estas soluciones, que es el principio indubio pro natura, ¿no? Ante la duda, debemos adoptar aquella solución que en mejor medida proteja los derechos de la naturaleza y de las generaciones futuras. Primer desafío. Segundo desafío, la gravedad y de la irreversibilidad de los daños a los bienes ambientales, a los bienes colectivos. Entonces, de nada sirve llegar con una solución para resarcir un daño ambiental, sino que lo que hemos desarrollado en nuestro continente son mecanismos de tutela inhibitoria, tanto en la fase procesal, por ejemplo, flexibilizando los requisitos de la acción de amparo, de las medidas cautelares, de las acciones preventivas, como en el fondo, en lo sustancial. En nuestro país, también en Brasil y en muchos otros del continente, tenemos un sistema polifuncional de responsabilidad civil. Entonces tenemos una función preventiva de la responsabilidad civil para supuestos de daños o riesgos ciertos y también tenemos una función precautoria de la responsabilidad civil para daños y riesgos inciertos o en falta de información científica. Entonces, hay un gran desarrollo en la jurisprudencia de nuestro continente en aplicación de estos principios preventivos y precautorios con una legitimación activa amplia, ¿no? No solamente el afectado por los daños puede accionar en tutela de los bienes comunes, sino que también lo pueden hacer las organizaciones no gubernamentales, el defensor del pueblo, el Ministerio Público, y los jueces y juezas, además, tienen la obligación, diría yo, de adoptar también, o pueden adoptar medidas preventivas o precautorias de oficio, ¿no? Esta idea del activismo judicial que viene en el tercero de los desafíos. Entonces, primer desafío, conflictos en derechos individuales y derechos de incidencia colectiva, solución a través de la noción de la función socioambiental en el ejercicio de los derechos individuales y del indubio pro natura. Segundo desafío, irreversibilidad y gravedad de los daños ambientales, solucionable a partir de los mecanismos de tutela inhibitoria, prevención, precaución. Y tercer y último desafío es uno que se ha trabajado muchísimo en todos los foros internacionales ambientales, muchos de los aquí presentes han participado y han trabajado mucho para ello. Y voy a citar también al profesor Antonio Benjamín, ya que no está aquí, lo vamos a mencionar una vez más. Él ha trabajado mucho la noción de el estado teatral del derecho ambiental, ¿no? Es decir, tenemos muchas normas ambientales, muchas leyes ambientales que a veces no se cumplen. Y entonces es fundamental el rol de los poderes judiciales, y en nuestro continente ha sido central el rol de las cortes, como se ha dicho, las cortes verdes de nuestro continente, que han trabajado en esta idea de la implementación del derecho ambiental y de las propias soluciones judiciales. En materia ambiental, la sentencia no es el acto procesal que pone fin al juicio, sino es el acto procesal que inicia la etapa más importante del proceso, cuál es la de la ejecución de la sentencia. Entonces, en esto nosotros tenemos en Latinoamérica un acuerdo, un tratado multilateral que se llama el Acuerdo de Escazú, que habla del acceso a la información, el acceso a la participación ciudadana y el acceso a la justicia. Y ahí establece el Acuerdo de Escazú el acceso a procedimientos rápidos, a sentencias que se cumplan y al seguimiento en la ejecución y en el control de las sentencias judiciales. En esto la Corte Suprema de Brasil y la Corte Suprema Argentina han hecho un camino muy largo. El ejemplo en Argentina es el de la cuenca Matanza-Riachuelo, que es un río enorme que involucra una cuestión socioambiental muy grave y que ahí la Corte Suprema durante casi 20 años ha monitoreado el cumplimiento de un plan de saneamiento y de recomposición de ese río que ha generado beneficios para una cantidad enorme de personas y también para las generaciones futuras. Y el año pasado, recientemente, la Corte Suprema dio por terminada su intervención y mostró en esa sentencia todos los logros que se han obtenido en estos últimos 20 años y, por supuesto, que dejó abierta la puerta para que en caso de producirse futuros niveles de contaminación puedan realizarse nuevas acciones judiciales. Entonces, tercer y último desafío que quería comentar con ustedes, la necesidad de que los poderes judiciales no nos quedemos solamente en el dictado de la sentencia, sino que trabajemos mucho más en la ejecución y en el control del cumplimiento. Cierro con una reflexión final muy breve relacionada con el objeto general o con el tópico general de este Congreso, que es el del Estado de Derecho. Los tribunales y los poderes judiciales de nuestro continente han trabajado muchísimo la idea del Estado de Derecho ambiental. No es posible hoy en día predicar la noción del Estado de Derecho sin incorporar la variable ambiental a todos los ámbitos. Por eso, como decía el presidente del panel, este es uno de los paneles más importantes de este Congreso, porque tenemos que incorporar a todas las variables de decisión, no solo en el Poder Judicial, sino en el Legislativo y en el Ejecutivo, siempre la variable ambiental y la noción de equidad intergeneracional. Sobre todo, y con esto cierro, en contextos como el que actualmente atravesamos, de medidas y de discursos claramente regresivos, no solo en materia ambiental, sino en materia de derechos fundamentales. Yo quisiera agregar a los países que se nombraron ayer en la apertura, quisiera agregar que no solo en los países de Sudamérica, en los cuales claramente hay violaciones a los derechos humanos y riesgos para el sistema democrático, sino que también hay otros países que son sistemas claramente democráticos y con gobiernos elegidos por los pueblos muy legítimamente y que además predican la tutela de las libertades, Bueno, en esos países hoy en día también estamos viendo discursos que son muy graves para la tutela de los derechos fundamentales. Menciono solamente un par de ejemplos. Piensen ustedes en los migrantes, piensen ustedes en las personas que tienen orientación sexual diferente a la general. Piensen ustedes a las minorías religiosas, a las minorías de género, ¿no? Hay discursos gravísimos contra esos derechos fundamentales y, por supuesto, también en materia ambiental. En materia ambiental no solo hay discursos, sino hay decisiones administrativas, legislativas, judiciales, que son regresivas. Por eso creo que tenemos que trabajar en el afianzamiento del principio de no regresión y en la consolidación del Estado de Derecho ambiental. Nada más y muchas gracias.
Thank you so much, Judge Lorenzetti, for your insightful presentation, where in the end we touched upon very big issues concerning the rule of law, which is the very essence of this conference. I also noticed that you mentioned Pope Francis, may he rest in peace. He was a very powerful man in the field also of environmental justice and global peace. So let's hope that his efforts will continue. But the next speaker is my close friend, Toni Fickentscher from Germany. And he has accomplished his doctoral thesis on constitutional law at the University of Regensburg. He's at the moment a notary candidate in the state of Bavaria, and he's also a trustee of the World Law Foundation. And he will share our thoughts on sustainable constitutionalism, the protection of future generations by the constitutions regarding climate change. Toni, please take the floor.
Thank you, President Kuusiniemi. It's a true honor to be with you on the panel. Very seriously, you're an example of professional excellence and personal integrity. I mean it very honestly. So, to be short, I would say the question of protection of climate change has left the political and social sphere and has come to the courts. And I want to show up, especially to constitutional courts, I want to show up very briefly that it is correct to say that protection of climate change can be linked and is found within a constitution. As, from my point of view, a constitution is a so-called living instrument. It adapts to realities and of the world and to people's ways of life. So it's not a fixed legal order, it is evolving in itself and has to take into consideration also future developments as the protection of the dangers of climate change. Secondly, I would add that the fundamental values that are in the Constitution do not only protect the individual against state measures, but do also contain objective values, a set of values. That means that the state also has the duty to protect the individuals by threats of third parties. There can be threats by personnel, but also threats regarding or that evolve by the dangers of climate change. So to put it another way, it was already said before, so I will keep here very short now, that the Constitution has an intertemporal dimension. And all in all, climate change is not an absolute principle. I would point out very clearly that one of the main principles, constitutional principle, the principle of proportionality, must always be taken into account. And I would say in the future it will be even more important, the balance between the parliament, the competence of a parliament, and the courts. So what is said or what can be, written down or thought under the so-called judicial self-restraint will be even more important in the future, meaning that I would say the courts need to find a way to find the right balance between their competences and the competences of the parliament. And from my point of view, it is a very, how to say, important task to remain on on these consequences and not to be too ideologically. As I would remember that, for instance, also the German Constitutional Court has said the first constitutional body that interprets the constitution is the parliament. So to summarize, with regard to the future, with regard to climate change, I would say we can found this the protection of the dangers of climate change within the constitution. The constitution has a future dimension, but at the same time, this protection is not absolute. It has always been measured against the other values of the constitution, and in the future, I think it will be even more important than today that the constitutional bodies, the constitutional organs like the courts or the parliament find the right way, find the right balance to act. Thank you very much.
Thank you so much, Tony. You were able to put very important things in a nutshell, and we were touching the very basics of the rule of law, separation of powers, climate change, and also duty to protect in the meaning of German Drittwirkung. Thank you. And now we are coming to an end, and if I may use the worn-out saying, last but not least, but this is definitely true in this case, we have the last speaker, Cristobal Diaz. Chris is going to shed light on the interplay between judges and scientists, a very intriguing topic. He's assistant director for international program at the Bulge Judicial Institute at Duke University Law School in the United States. He joined the institute a couple of years ago after serving 8 years in Prague. And for the last decade, he has developed and facilitated international rule of law programs for a wide array of stakeholders all over the world. And now I think it's time to leave the last word to Chris. Please, the floor is yours.
Thank you very much, Judge Kuusiniemi, for the introduction. Y muchas gracias a todos ustedes por estar aquí con nosotros. I'm going to speak in English because I can go faster, and I know that we're under time. But it's a true privilege to be here amongst these panelists speaking a little more practically, I think, about what we can do at the intersection of rule of law and climate change. So as Milagros noted, judges need empowerment in order to rule on these cases, in order to provide equitable and proper justice. So a collaborative initiative that my organization, the Bulge Judicial Institute, has been working on with the Environmental Law Institute's Climate Judiciary Project based in DC. The initiative is an outstanding example of what's needed to prepare judges for the growing wave of climate litigation. They will not only be expected to adjudicate, but also understand how they're ruling. As everyone knows, climate-related cases are no longer just niche legal battles. They are becoming mainstream. And the questions they pose are vast, complex, and quite frankly, unlike anything most judges have dealt with before. So why is this program so crucial? As of the end of last year, the number of climate-related lawsuits across the world has skyrocketed, with over 2,500 cases currently being tracked globally. And we're seeing cases emerge across nearly every facet of law. Environmental, human rights, property rights, corporate liability, insurance, migration, and asylum have all been affected by climate change. The legal challenges are multiplying in direct response to our challenging climate. But the problem is that many of these cases require judges to engage with highly technical, rapidly evolving climate science. From understanding emissions modeling to interpreting the latest findings on climate impacts, judges are being asked to make decisions that hinge on complex scientific concepts. Yet most judges, while experts in law, are not trained in climate science. And I'm sure many in this room, and hopefully nobody will take offense, but they know that judges are stubborn often, and judges and judges can be difficult to teach at times. So that really poses a complex puzzle for us when we're trying to instill them with new knowledge about something they may not have been exposed to previously. That being said, they may not fully understand the science behind rising sea levels, heat waves, or the attribution of specific weather events to climate change. However, they will be expected to adjudicate cases based on this knowledge. This creates a critical gap, and that's exactly what we're trying to address in these projects that we've created. We have created a robust program designed to equip judges with the tools they need to handle climate cases effectively. Through seminars, workshops, and intensive courses, judges are exposed to climate science in a way that's tailored to their needs. They don't just receive lectures from experts, they engage in discussions with scientists, legal scholars, and practitioners who help bridge the gap between legal reasoning and scientific evidence. Recently, during a pilot initiative for European judges, which was held in October of 2024, participants from over 15 countries heard from world-renowned scientists like Professor Miles Allen of Oxford, who is one of the pioneers in climate attribution science. They learned about the latest developments in climatological risk assessments and explored how these insights are increasingly central to understanding environmental cases. The program also covered legal frameworks, international treaties, and judicial responsibility in environmental law. These courses are designed not only to inform, but also to empower judges to navigate the specific scientific questions they'll face in the courtroom. But one of the most important takeaways from these programs is the emphasis on creating a dialogue between judges and experts, particularly in the way that they communicate. While the science behind climate change is complicated, the way scientists present the sciences to judges is often equally as important. Scientists need to be able to distill complex data into language that judges can understand without oversimplifying or misrepresenting the evidence. On the flip side, judges need to be able to ask the right questions, clarify uncertainties, and engage in conversations with experts in a way that helps them arrive at sound, informed decisions. In the United States, this has become increasingly important with the Supreme Court's overturning of the Chevron doctrine, essentially taking away certain statute interpretation powers from agency experts and giving that power to judges. This program isn't just about passing on knowledge either. It's about creating a framework for dialogue. One of the challenges we face with hot-button issues like climate change is the trust deficit that can exist between judges and experts. Scientists can find it difficult to speak to judges in a way that resonates, while judges may feel overwhelmed by the scientific complexity of the information they're receiving. By bringing together these groups in a neutral, structured setting, this program helps cultivate mutual respect, understanding, and trust. And the feedback from participants has been overwhelmingly positive, with one of the most consistent themes in evaluations being the desire for additional, more in-depth programming. Judges want to deepen their understanding of climate science, but they also want more guidance on how to communicate with scientists and other experts. They're asking for regional programming, more in-depth modules on specific scientific areas, and for ways to connect with their judicial peers across jurisdictions. Interestingly, one of the most frequent requests has been for more opportunities for judges to learn from one another. This is a key aspect of the program's design. Judges not only gain knowledge from scientists, they also learn leadership and communication skills that allow them to become ambassadors for this knowledge within their own judicial communities. In the United States, the Climate Judiciary Project has used similar model in several programs where judges are trained on climate science and leadership, after which they are expected to lead their own programs, whether that be webinars, roundtables, local seminars, back in their home jurisdictions. This is something we're now working with an international audience to provide to judges around the world. This peer-to-peer learning model is one of the most effective ways to disseminate knowledge. When judges share their insights with one another, it creates a sense of shared purpose and understanding that is crucial when tackling diverse and complex issues like climate change. Judges are often more open to hearing from fellow judges because they recognize the unique challenges and responsibilities that come with their roles. This trust between judges fosters a richer exchange of ideas and strategies, ultimately leading to better informed decision-making across the judiciary. It's also important to note that the role this type of programming can play in fostering leadership. After participating in these training programs, judges are not just recipients of information, they become leaders in their communities. They're empowered to engage with their peers, organize climate-related educational events, and play a critical role in shaping the discourse around environmental law. This causes a powerful ripple effect that ensures that knowledge doesn't stay confined to a small group of experts. It expands outward, influencing judicial thinking on a broad scale. But beyond education and leadership, there's also a much larger goal at play. The decisions that judges make in climate cases will have far-reaching consequences for our societies, our economies, and the environment. As we see the repercussions of climate change become more pronounced, from extreme weather events to widespread migration and environmental damage, judges will need to be equipped not just with the facts, but with the tools to make tough, informed decisions that align with both scientific realities and the legal frameworks in place in their jurisdictions. This is where the collaboration between BOLCH and the Environmental Law Institute becomes indispensable. In closing, we believe the importance of this program cannot be overstated. As we witness the increasing frequency of climate-related lawsuits around the world, judges must be prepared not only to understand the science, but also to communicate effectively with experts and lead discussions within their judicial communities. The partnership between BOLCH and the Climate Judiciary Project is an essential step towards ensuring that our legal systems are equipped to handle the most pressing environmental issues of our time. Thank you very much.
Thank you so much, Chris. I didn't promise too much. It was a very important intervention, and I couldn't agree more that judges dealing with environmental cases must have a basic knowledge on science and technology, and there must be a fruitful discourse on this. And also in Europe, we are just discussing the Chevron deference doctrine and its implications. Thank you so much, all your panelists, our panelists. It was a great time to listen to your insightful interventions. I'm terribly sorry that we are running late. That's always on the responsibility of the chair. But judging by the number of our spectators, the panel was a success. Thank you so much.